Usually when we think about a conversation, we picture something organic, like a river.
Right, yeah, it just sort of flows naturally.
Exactly. It flows, it meanders, maybe sometimes it rushes or pools in these quiet little eddies, but it feels entirely natural.
Yeah, spontaneous. Two people just kind of reacting to each other in real time, relying on instinct, social conditioning.
But imagine if, instead of a river, a conversation was a blueprint.
Ooh, okay.
Like a highly engineered piece of machinery where every single pause, every micro shift in the pitch of your voice, every specific grammatical structure of a question is deployed with like the precision of a scalpel.
Wow, yeah.
Where absolutely nothing is left to chance and every word serves a calculated tactical purpose.
Well, that completely changes the paradigm, doesn't it? From just communication to controlled manipulation, really. It turns a basic human function into a strategic operation.
It does, and that is the exact premise of the manual we are looking at today. It's called Oral Skills for Lawyers.
The fourth edition. Right.
Yeah, the fourth edition, published by the University of Law, and this is the official training text specifically designed for aspiring solicitors in England and Wales who are facing this SQE2 assessment.
Right. And just for context for you listening, the SQE2, that's the Solicitor's Qualifying Examination Stage 2, is basically the final brutal hurdle to becoming what they call a day one solicitor.
Day one.
And it is entirely focused on practical legal skill.
Exactly. And we are taking a deep dive into this today, not because you need to go pass a British law exam, but because this manual is secretly a masterclass in human psychology and persuasion.
It really is.
The legal profession has essentially taken the messy, entirely unpredictable nature of human interaction and just mapped it out into a precise, accessible science.
Accessible being the key word there.
Yeah.
They literally grade candidates on how well they can control the hidden levers of human dialogue.
It's wild. And the tools in this book, you can lift them straight out of the courtroom and apply them to your own life. Whether you're negotiating a raise or, I don't know, arguing with a contractor over a shoddy renovation or just navigating a truly terrible Thanksgiving dinner.
Right? We've all been there.
Yeah. This is basically a shortcut to mastering the mechanics of persuasion without needing a law degree.
And the foundational premise of the manual is just striking. It immediately forces the candidate to grapple with this massive shift in the industry, which is the move away from the written word and back toward raw oral communication.
Which, that feels entirely counterintuitive, right?
Right.
Because we live in an era where everything is asynchronous. We use Slack, text messages, email threads that go on for years. The written word feels safer because it's a permanent record. So why is a modern legal manual suddenly demanding mastery of the spoken word?
Well, it really comes down to the psychology of immediacy and, frankly, the limitations of text.
Yeah.
The manual points out that clients today are in a constant state of urgency. Yeah. So if a client is facing bankruptcy or a looming divorce, an email detailing the nuances of family law doesn't exactly soothe their central nervous system.
No, it probably makes it worse.
Exactly. Oral communication provides instant feedback. But more importantly, from a strategic standpoint, speaking allows the lawyer to read nonverbal cues and instantly course correct if the client's misunderstanding the advice.
Right, because you cannot read a panicked facial expression through an email.
You really can't.
But the manual explicitly acknowledges the danger here, doesn't it? Because there is no editing button for the spoken word.
None at all.
When you type an email, you can draft it, delete it, maybe soften the tone, run it by a colleague. But when you are speaking, the moment a word leaves your mouth, it is permanent.
It's out there.
Yeah, and unless you have a recording device running, there is no formal record of what you promised or what advice you gave.
Precisely. It is high-wire communication without a net. And that is why the manual insists that a lawyer must master their primary physiological instrument before they even think about legal theory.
The voice.
They have to control their voice.
This was fascinating to me because it doesn't just say, speak clearly. It breaks the voice down into mechanical component.
Right. Pitch, volume, pace, and tone.
And when it addresses pitch, it isn't giving a dictionary definition. It's addressing the autonomic nervous system.
Yeah, and this is where the biological reality of stress collides with professional performance.
Okay, unpack that.
So when you are in a high-stakes scenario, say a client is screaming at you or a judge is just glaring down at you, your body releases adrenaline.
Fight or flight.
Exactly.
Yeah.
And one of the physiological responses to that stress is that your vocal cords physically tighten.
And when your vocal cords tighten, your pitch artificially spikes. Your voice gets higher, thinner, tighter.
Right. And humans are evolutionarily conditioned to interpret a high, tight pitch as a signal of distress, submission, or just a lack of confidence.
Wow.
The listener might not consciously realize why, but their brain instantly registers that the speaker is not in control of the situation.
That is incredible.
And here's the crazy part. The assessor for the SESQE2 exam, who is acting on behalf of the solicitor's regulation authority, is literally sitting there with a rubric grading candidates on this exact physiological response under their performance indicators.
Wait, really? So if your voice squeaks because you're nervous, you lose points?
Yes. If your pitch spikes because you let the stress of the interview overwhelm you, you lose points because in the real world, you just lost the client's confidence.
It is wild that they grade you on your ability to suppress a biological stress response.
It's intense.
And the same goes for pace, right? The manual notes that our natural tendency when we're anxious is to speed up.
Oh, absolutely.
We feel this intense pressure to just expel the information and end the uncomfortable interaction as fast as possible.
Which is catastrophic when you are dealing with complex information.
Right, I was thinking about this like a musician using a metronome. If you play a complex Chopin piece at double speed, the audience doesn't hear the genius of the composition.
No, they just hear noise.
Yeah, a wall of chaotic noise. They can't process the melody, so if a lawyer speeds through an explanation of, say, contingent liability or trust structures, the client's cognitive load maxes out instantly.
They just stop listening.
They stop listening and just nod blankly, hoping it's over soon. But on the flip side, if you talk too slowly, you sound condescending, and they check out entirely.
Exactly.
You have to actively fight your own nervous system to maintain a steady, authoritative metronome.
And this mechanical control becomes even more critical when you remove face-to-face interaction. The manual stresses that during a phone call or a video link, your tone has to carry the absolute entirety of your empathy, your contrition, or your authority.
Because they can't see your body language?
Right. If a lawyer delivers bad news in a flat monotone, the client doesn't interpret that as professional distance. They interpret it as a callous lack of interest in the destruction of their life.
Oh, wow. Yeah, that makes perfect sense. And then there are the verbal tics. The manual explicitly targets the fillers we all use to bridge thoughts, the ums, the likes, the you-knows.
Yeah, it demands the complete eradication of those fillers because they dilute authority.
Which is so hard to do.
It is. But the alternative to a verbal filler isn't just speaking flawlessly. It's learning how to weaponize the absence of speech entirely.
Ooh, I like that phrasing.
Which brings us to the manual's breakdown of listening, specifically what it calls passive listening.
Yeah, passive listening is such a deceptive term because it makes it sound lazy.
Right.
But the manual describes it as the deliberate, calculated use of silence combined with unobtrusive signals like nodding or just a quiet uh-huh.
Yes.
But I need to push back on this mechanically for a second. If I'm talking to you and I finish my sentence and you just sit there staring at me in total silence,
It's awkward.
I am going to feel incredibly weird. It violates every rule of normal social etiquette.
But that violation of social etiquette is the exact mechanism that makes it work. Yes. From childhood, we are socially conditioned to view silence in a conversation as a failure. Anthropologically, humans use continuous chatter to signal safety, much like birds singing in a forest.
Oh, that's a great analogy.
Right. When the forest goes quiet, it means a predator is nearby. So when a conversation goes silent, our nervous system registers discomfort. We feel an overwhelming, almost compulsive urge to fill the void, to restore that feeling of social safety.
So the lawyer is exploiting an evolutionary glitch.
Precisely. By suppressing their own urge to speak, by simply holding the silence and maintaining eye contact, the lawyer forces the other person to bear the weight of that discomfort.
And they crack.
The client or the witness will rush to fill the silence. And because they're panicked and speaking off the cuff to alleviate the tension, they frequently drop their filter.
They just start babbling.
Yeah, they will volunteer crucial, damaging, or highly emotional information that they would have heavily edited if the lawyer had just asked them a direct question.
It's cognitive redirection. You aren't interrogating them. You are letting their own social anxiety do the interrogating for you.
Exactly.
I mean, think about that the next time you are negotiating the price of a car. Make your offer, and then just shut your mouth. Let the salesperson squirm in the silence.
It's incredibly effective.
Mm-hmm.
But the manual pairs this with active listening, which is a much more obtrusive tool.
Right.
This is where the lawyer explicitly summarizes the facts and reflects the underlying emotion back to the speaker. Saying something like, I hear that you felt completely betrayed when your business partner signed that contract without telling you.
So it proves you aren't just a legal robot logging data.
It
You are
gets
confirming their emotional reality, which builds the trust necessary to actually get them to follow your advice later.
which is the perfect bridge into how these raw vocal mechanics are actually deployed in practice. Because having a controlled pitch and knowing how to use silence is fine in theory, but the manual immediately drops the candidate into a high-pressure scenario,
With the client interview.
the client interview.
Right, the crucible of the SESQE2. Let's look at the constraints the manual lays out for this assessment, because honestly, it sounds like an absolute nightmare.
It really does.
The candidate gets exactly 10 minutes to prepare. They are handed a brief, maybe an email from a senior partner outlining a vague legal issue, and they have 10 minutes to formulate a strategy.
10 minutes is nothing.
Nothing. Then they walk into a room and have 25 minutes to interview an actor playing a client.
And this isn't just someone reciting facts. The actor is instructed to be hostile or to ramble inconsolably or to be incredibly guarded.
And the moment that 25-minute interview ends, the candidate leaves the room and has exactly 25 minutes to handwrite a comprehensive, legally sound attendance note.
Handwrite. We'll get to that later, but yeah.
Yeah, so you have less than an hour to extract a lifetime of chaos from a stranger and convert it into actionable law. To survive this, the manual mandates a rigid 6-stage interview model.
Greeting, opening, listening, filling in the detail, advising, and closing.
The greeting and opening stages are fascinating to me because they dictate a very strict professional etiquette that completely supersedes the client's immediate needs.
Right.
When a traumatized person walks into an office, their instinct is to just start vomiting their problem onto the desk, but the lawyer is trained to halt them.
Yes. You have to establish the parameters of the relationship before you touch the trauma.
Right.
The manual insists that the lawyer must first check for conflicts of interest, ensuring you don't already represent the person who just hit them with a car, for instance.
Which would be awkward.
Very. You have to explain the cost structure up front. You have to outline the firm's complaints procedure.
And if the candidate skips these structural pleasantries out of a desire to just rush to the legal issue, they fail the trust and confidence metric.
Exactly. The assessor wants to see that the lawyer can impose institutional order on a chaotic emotional situation. It creates a psychological boundary that actually makes the client feel safer.
And once that boundary is set, we enter the listening stage. And this is where the manual introduces what I think is the most powerful conceptual tool in the entire book.
The T-funnel.
The T-funnel questioning technique.
The T-funnel is the architectural foundation of a successful investigation.
The visual is perfect.
Right.
So, for you listening, picture a capital letter T. You always start at the top, the wide horizontal bar.
Right.
These are broad, open questions. Tell me what led up to you coming here today. Walk me through what happened at the office.
Yes, very broad.
You are giving the client absolute freedom to choose where the narrative starts and what details they think are important. Only after you have completely exhausted that wide top bar do you move down the narrow vertical stem of the T, shifting to highly specific closed questions.
Like, what date did you sign the lease? Or were you drinking before you got in the car? The psychological discipline required to stick to the T-funnel is immense. Lawyers, by nature, are analytical problem solvers. They want to diagnose the issue immediately. But if a lawyer starts with the narrow stem, if they start with closed questions, they are creating a massive cognitive guardrail that actually damages the case.
Explain that mechanism. Why is starting with a direct question dangerous?
Well, it's a form of confirmation bias. If a client sits down and says, "I'm having a dispute with my landlord," and the lawyer immediately asks, "Did you fail to pay rent on the first of the month?" The lawyer has already unconsciously decided what this case is about. They are projecting a standard eviction scenario onto the client.
Right.
The client answers yes, and the lawyer goes down a highly specific legal rabbit hole regarding eviction notices.
But what if the lawyer had used an open question at the top of the T?
Exactly. If they say, "Tell me about the situation with your landlord," the client might say, "Well, I stopped paying rent because the roof caved in, and when I complained, he threatened me with a baseball bat."
Oh, wow. So the whole paradigm of the case changes. Yes.
It goes from a routine civil eviction to a criminal harassment and habitability issue.
Exactly. By starting with closed questions, the lawyer's own cognitive biases literally railroad the client's story. The T-funnel forces the lawyer to let the client build the universe of facts before the lawyer starts organizing the legal constellations.
That is so applicable to everyday life. I mean, think about a manager talking to an underperforming employee.
Oh, perfect example.
If you start by asking, why didn't you finish the Q3 report on time? You're trapping the conversation in a defensive cycle about time management.
Right.
But if you start at the top of the T-funnel saying, talk to me about how your workflow has been going this quarter, they might reveal that another department is actively sabotaging their data access.
Yeah, you have to let them map the terrain before you start digging holes.
Exactly. But the manual also prepares the candidate for when the T-funnel fails, because clients are human and humans are difficult.
They are.
So the manual has specific protocols for what it calls bad clients, though I know it frames it as managing vulnerability and hostility.
Right.
What happens when the client just won't stop rambling?
Well, when a client is rambling, the broad horizontal bar of the T-funnel has become a liability.
Because they'll just talk forever.
Exactly. The open questions have failed. So the manual dictates that the lawyer must adopt a forceful breaking role. They have to actively interrupt, use the active listening technique to validate the emotion, saying something like, I hear how stressful this timeline is, and then abruptly shift to the narrow stem of closed questions to corral the client back to the legally relevant facts.
You essentially have to build a verbal fence to keep them from wandering off.
Precisely.
But the scenario that really caught my eye was how the manual handles a client who you suspect is lying to you, or at least heavily editing the truth.
Yes. The devil's advocate.
The manual suggests a technique of playing devil's advocate to test the structural integrity of the client's story, and it gives this incredibly intense example of a lawyer saying to their own client, you say you were deeply devoted to your father. If that's true, why didn't you ever visit him in the care home? It is a profoundly aggressive tactic.
Wait, I really need to push back on this. Because if I am paying a lawyer hundreds of pounds an hour, and we were 15 minutes into our first meeting, and they suddenly pivot and start interrogating my love for my dead father,
You'd be furious.
I am standing up and walking out. I'm firing them. How does the manual justify that risk? Does this actually work in practice without destroying the rapport they just spent the entire greeting stage trying to build?
It only works if the lawyer employs extreme tactical empathy. The manual is very clear that you cannot deliver that challenge as a personal accusation.
Okay.
You have to preface the challenge with a shared explanation. You reframe the attack. You say, look, I need to ask you a very difficult question. I know how much you cared for your father, but the opposing counsel is absolutely going to look at these visitor logs, and they are going to try to use your absence to prove you didn't care. We need to figure out our response to that right now so they can't ambush us.
Okay, that is a brilliant pivot. You take the accusation and you offload it onto a hypothetical future enemy.
Precisely. You align yourself with the client against the opposing side. You are testing the exact same vulnerability in their story, but psychologically, you are doing it from inside their fortress, looking out at the threat together.
Right.
It transforms you from an interrogator into a protector.
That is the kind of social engineering that makes this manual so fascinating. So, okay, you've survived the 25-minute interview, you've navigated the T-funnel, you've played devil's advocate, you've managed the emotional outbursts. Now, the candidate leaves the room. And this brings us to the ultimate administrative trial.
The attendance note.
The attendance note. This is where the raw data of human interaction must be transmuted into a formal legal record.
Right.
In the SEC-UE2, as we mentioned earlier, the candidate has precisely 25 minutes to write this attendance note, and they must write it by hand.
By hand, yes.
Which completely baffled me at first. In the modern digital age, where every law firm relies on encrypted cloud servers, dictation software, and laptops, why on earth is the Solicitor's Regulation Authority testing handwritten notes under extreme time pressure? It feels like, I don't know, testing a pilot's ability to navigate by the stars when they have GPS.
It definitely feels archaic, but it is actually testing a very specific, highly sophisticated cognitive skill, which is real-time synthesis.
Okay.
When you type on a laptop, your brain can easily slip into transcription mode. You type so fast that you can record almost everything the client says without actively processing what it means. It's mindless data entry.
Right, you're just a court reporter at that point.
Exactly. But handwriting is mechanically slower. Because you physically cannot write down every word, your brain is forced to actively filter the information in real time.
You have to make choices.
Yes. You have to listen to the client's rambling, instantly decide whether it has legal relevance, synthesize it into a concise concept, and commit it to paper.
Sure.
It forces the candidate to separate the legal signal from the emotional noise. The SRA is testing legal judgment, not typing speed.
That makes perfect sense. The cognitive friction of handwriting forces you to analyze, not just record. And the manual makes it clear that this piece of paper is the most important document in the entire case file. Because in the eyes of the law, if the conversation wasn't documented perfectly, it didn't happen.
The attendance note serves three critical structural functions. First, it is the primary memory aid. A lawyer might not look at this file again for 6 months.
Sure.
Second, it is the blueprint for continuity. If that lawyer gets hit by a bus tomorrow, a colleague needs to be able to pick up that note and instantly know the facts, the legal analysis, and the agreed-upon next steps.
And the third function?
It is the ultimate shield against professional negligence. Years down the line, a furious client might sue the lawyer, claiming, "You never warned me about the tax implications of this settlement." The only defense the lawyer has is an attendance note from 3 years ago that specifically documents, "Advise client on potential capital gains tax liability, client acknowledged risk."
It is a self-preservation mechanism.
Absolutely.
But what happens when the lawyer messes up? Because the manual has a fascinating protocol for handling errors in this note. Imagine you are sitting in the exam room, frantically handwriting your note, and suddenly your stomach drops. You realize, oh my God, the client was talking about a commercial lease, and I completely forgot to ask if there was a break clause. Or worse, you realize you confidently gave them the wrong advice about an inheritance tax threshold.
Well, human nature, especially in a high-stakes exam setting, is to bury the mistake.
Of course.
You convince yourself it wasn't that important, or you hope the assessor just doesn't notice the omission.
But the manual says hiding it is a fatal error.
Absolutely fatal. The manual explicitly instructs candidates that if they realize an error or omission while writing the note, they must overtly admit it on the page and immediately outline the corrective steps.
You literally write it down.
Yes. You write omission, failed to confirm existence of break clause, action. We'll call client tomorrow morning at 9 a.m. to clarify.
You actually score points for documenting your own incompetence.
Because it isn't viewed as incompetence, it's viewed as professional accountability. The SRA understands that day one solicitors are going to make mistakes. The legal system can survive mistakes, provided they are caught and corrected.
Right.
What the system cannot survive is a culture of concealment. Hiding an error demonstrates a fatal flaw in ethical character. Acknowledging the error and demonstrating the practical sense to formulate a plan to fix it proves to the assessor that you possess the integrity required to be an officer of the court.
It's the ultimate test of ego suppression for the sake of the client. Okay, so we've mastered the interview, we've codified it in the attendance note. Now, the manual shifts gears entirely. We are moving from the quiet, carpeted confines of the solicitor's office to the absolute theater of the courtroom. How does a lawyer prepare for courtroom advocacy?
The parameters of the assessment shift dramatically here. The candidate is no longer extracting facts from a client. They are imposing a narrative on a judge.
Right.
They were given 45 minutes to read a complex case file and prepare a 15-minute oral submission. They have to identify the relevant law, map out the facts, acknowledge the strengths of their case, and prepare for the weaknesses.
But the part of this preparation phase that I found incredibly profound was the mandate to hunt for gaps and inconsistencies.
Yes, the gaps.
The manual provides a brilliant example to illustrate this. Let's say a defendant is refusing to pay a roofer for a job. The defendant's entire narrative is that they are withholding payment because it was shoddy work.
Right, that is the affirmative story they are telling.
So an average advocate looks at the file, sees the claim of shoddy work, and starts preparing arguments about the legal definition of a breach of contract regarding workmanship.
Yeah.
But the manual trains the elite advocate to look at what isn't in the file. The advocate notices that the roofer finished the job in May. The bill was sent in June. The refusal to pay happened in July. But nowhere in the file is there a single email, text, or phone record of the defendant complaining to the roofer in May when the work was supposedly ruined.
This is a profound shift in analytical thinking. The best advocates don't just read the evidence that is explicitly on the page. They read the negative space. They read the absence of evidence.
Argue the negative space. Mechanically, how does a lawyer use that in court?
Well, they use the gap to destroy the logic of the opponent's narrative. The advocate asks themselves, what should a normal, rational human being have done in this scenario if their story were actually true?
Right.
If you hire a roofer and the first time it rains, water pours into your living room, what do? You don't quietly wait 2 months for the invoice. You call the roofer immediately. You take photos on your phone. You send angry emails demanding they fix it.
Exactly.
The manual trains the lawyer to weaponize the silence in the record. You stand up in court and say, "Your Honor, where are the frantic emails from May? Where are the photos of the leak?" They don't exist. And they don't exist because the work wasn't shoddy. The defendant simply ran out of money.
You dismantle their defense using the evidence they failed to create.
It's brilliant.
This is something every listener should apply immediately. Think about the last time you were arguing with a passive-aggressive coworker who claimed they didn't know the deadline had moved. Did you just argue about what was said in the meeting, or did you point to the gap?
Point to the gap.
Yeah, if you didn't know the deadline moved, why didn't you submit your draft on the original date? The absence of their work is the evidence that destroys their excuse.
It's a devastating logical tool. But while the candidate is hunting for these gaps during their 45-minute prep, they're also navigating a terrifying ethical minefield. The manual dedicates significant time to the inherent tension between the SRA principles, specifically the collision between Principle 7 and Principle 1.
The clash of duties. Principle 7 states that a lawyer must act in the best interests of their client. You are their champion. You are paid to win their case.
But Principle 1 states that you must uphold the rule of law and the proper administration of justice. You owe a fundamental duty to the court itself.
And the manual gives a hypothetical scenario that perfectly illustrates what happens when these two principles smash into each other. It feels like a scene straight out of a legal thriller.
It really does.
Imagine a lawyer is in the middle of a trial. It's going incredibly well. The opponent's arguments are crumbling. The court breaks for lunch. The lawyer is sitting on a bench, eating a sandwich, casually scrolling through a legal database on their phone. And they stumble across a breaking law report, a brand new legal precedent from a higher court that was just published that morning. And this new precedent absolutely fundamentally destroys their client's case. It invalidates their entire central argument.
It is the ultimate nightmare scenario.
So what does the lawyer do? The opposing counsel hasn't seen the new case. The judge hasn't seen it. The lawyer's client is paying them thousands of pounds to win. Does the lawyer just close their phone, walk back into court after lunch, and keep their mouth shut?
It goes against every instinct of a competitive advocate, but the manual is utterly unambiguous. Paragraph 2.7 of the Code of Conduct dictates that they must tell the judge.
You have to voluntarily sabotage your own case.
You are legally and ethically obligated to draw the court's attention to relevant cases, even if, especially if it is fatal to your client's case. Because the duty to the court under Principle 1 always, without exception, supersedes the duty to the client under Principle 7.
That is completely counterintuitive to the pop culture image we have of the shark defense attorney who will do anything, hide any document, twist any truth to get their client off. Mechanically, why does the system require the lawyer to punch themselves in the face in front of the judge?
Because the entire British legal system and adversarial system relies on the assumption that the judge is ruling on a complete and accurate foundation of law. The judge relies on the advocates to provide the map.
Right.
If an advocate intentionally hides a giant sinkhole on that map, they are corrupting the administration of justice. You are an officer of the court first, and an advocate for your client second. If a lawyer misleads the court by omission, they aren't just losing a case, they will be struck off. They will lose their entire career.
So you walk into court, you disclose the precedent, you lose the case, and you preserve the integrity of the system. That is a heavy burden to carry into the room.
Very heavy.
Which brings us perfectly to the actual performance. You've prepped your arguments, you've checked your ethics, it is time to stand up and speak. This section of the manual breaks down the bizarre, highly choreographed theater of the courtroom. And it really is theater, complete with stage directions.
The physical etiquette is incredibly rigid, and it is all designed to enforce a strict hierarchy. A lawyer must bow when entering or leaving a courtroom if the judge is seated. They must stand immediately when the judge enters. They cannot put their hands in their pockets. They cannot lean casually on the lectern. They cannot check their phone.
And the titles. The nomenclature is a minefield of deference. You have to know exactly who you were talking to, because getting it wrong instantly broadcasts your inexperience to the room. If you are standing before a high court judge, they are addressed as my lord or my lady. If it's a circuit judge in the county court or crown court, it is your honor. If it is a district judge or a panel of magistrates, you use judge, sir, or madam, or your worships.
But the physical bowing and the ancient titles are just the superficial layer. The most fascinating part of courtroom theater is the psychological control embedded in the language. The manual explicitly forbids certain colloquial phrases that we use every single day. The most prominent ban is on the phrase, I think or am, in my opinion.
This blew my mind. You were standing there arguing a case, but you were not allowed to say what you think. Why?
Because, mechanically speaking, your opinion is entirely legally irrelevant. You are an instrument of the client and a servant of the court. You are not the decision maker.
Ah.
If an advocate stands up and says, I think my client is innocent, the judge's implicit and sometimes explicit reaction is, who cares what you think? You're being paid to be here. Give me the law, not your personal feelings.
So how do you argue passionately if you can't state your opinion? Here is where the manual outlines a concept that I love: the language of submission. Instead of I think, the manual demands phrases like, I submit, I would urge you to find, or my instructions are.
It is a complex verbal dance. The lawyer must aggressively rip apart the opponent's legal arguments. They must fight tooth and nail for their client's life or livelihood, but they must mask all of that intellectual aggression in an aura of total linguistic submission to the judge.
Deferential dominance. That's what it is.
Oh, I like that.
Yeah, you say things like, if I may briefly address you, Judge, or I would seek to persuade you. It's velvet draped over iron. You stroke the ego of the authority figure while simultaneously backing them into a logical corner where they have no choice but to rule in your favor.
Exactly. By submitting linguistically, you dominate logically. You remove any friction of ego between you and the judge, allowing your argument to slide right into their decision-making process.
Which is brilliant.
And this is a tool anyone can use. If you are arguing with a stubborn boss about a project direction, don't say, I think my idea is better. That triggers their defensive ego. Say, if we look at the Q3 data, it suggests this alternative route might protect our budget. I'd seek to persuade you to consider this option. You give them the authority, but you control the logic.
But the manual warns that you must maintain this deferential composure even when the theater suddenly breaks down. Because judges are not passive audiences, they interrupt.
Constantly, a judge will cut an advocate off mid-sentence, demand they point to a specific subparagraph on page 400 of a dense evidentiary bundle, or challenge a fundamental premise of the argument the advocate thought was totally secure.
This is why the manual has a strict rule. Do not ever write a script. If you write out your opening statement word for word, you are dead in the water. First, because reading a script destroys your ability to maintain eye contact and project authority, but mainly because the second a judge interrupts you, your script is useless. You lose your place on the page and the panic sets in.
The manual advises creating an advocacy plan based on flexible bullet points. And if a judge rattles you or asks a question that completely derails your train of thought, the protocol is simple but psychologically difficult. You stop speaking.
Just stop.
You do not babble. You do not guess. You take a breath, you tell the judge you just need a moment to consult your notes, you find your place, and you proceed.
And under no circumstances do you ever make up evidence or twist a legal citation just to fill the awkward gap and please an irritated judge.
It loops right back to principle 1. If you don't know the answer to a judge's question, you admit it. I cannot assist the court with that point at this moment. Integrity and duty to the court always trump the desire to perform flawlessly.
Okay, we have covered an immense amount of theory. We've gone from autonomic nervous system reactions to the ethics of self-sabotage. To bring all these abstract, high-level skills together, we need to see them in action.
Yes, let's do it.
And the manual provides a brilliant, highly detailed criminal case study to show exactly how an elite advocate deploys these techniques in real time. It is the case of Gareth Davies.
This case study is the perfect synthesis of everything we've discussed. It illustrates the mechanics of a bail application and a plea in mitigation. Let's establish the facts of the scenario.
Okay, it's a classic Friday night disaster. We have our primary defendant, Gareth Davies, and his friend, the co-defendant, Stephen Jones. The setting is a pub, followed by the Seagull Fish and Chip Shop in a town called Wayford late at night. There is an altercation which results in a violent physical assault on a bouncer named Philip Bennett. Both Gareth and Stephen are heavily intoxicated.
The initial police reports show that Stephen threw the first punch, but Gareth quickly joined the fray. However, during his initial police interview, Gareth tells a completely different story.
Of course he does.
He claims he was entirely innocent. He states that he was just trying to pull Stephen off the bouncer, acting as a peacemaker, and that Stephen caused all the injuries.
But Gareth makes a massive unforced error. He is so furious that his friend Stephen is blaming him for the assault that while he is sitting in the police station, Gareth verbally threatens Stephen in front of the officers.
Unbelievable.
He literally shouts, "I'll get him for this. You wait until I catch up with him." Which is just the absolute worst thing you can have recorded on the charge sheet.
So we move to the first courtroom scenario, the bail application. Gareth is sitting in a cell. He desperately wants to be released pending his trial. The prosecution wants him remanded in custody.
And the prosecution stands up and builds a massive wall of objections based on the Bail Act 1976.
Yeah.
They have three primary arguments for why Gareth should stay locked up. First, a history of failing to surrender to bail. Second, a high likelihood of interfering with witnesses. Third, a risk of committing further offenses while on bail.
The prosecution uses Gareth's own life against him. To prove the failure to surrender point, they pull his criminal record, showing past convictions for ABH actual bodily harm, where he previously breached bail conditions. To argue he will commit further offenses, they highlight his complete lack of community ties, noting that he is currently unemployed and sleeping on random friends' floors because his wife recently threw him out.
And for the interfering with witnesses point, they just dropped that quote from the police station right into the judge's lap. He threatened his co-defendant in front of sworn officers. Your Honor, it looks incredibly bleak. The prosecution has built a fortress.
But then, the defense advocate stands up, and we see the manual strategies deploy beautifully. The advocate doesn't panic. They systematically dismantle the prosecution's wall, argument by argument. Let's look at how they attack the failure to surrender history. The prosecution relied on the raw data. He has absconded before. The defense advocate applies context to shrink that data. They look at the specific underlying facts of those past failures. They stand up and say, "Judge, it is true my client failed to surrender twice in the past. But let us look at the reality of those failures. The first was a simple clerical mistake regarding the date. He appeared the very next day. The second occurred because he overslept and he turned himself in 3 hours later. He did not flee the jurisdiction. He did not attempt to evade justice. And crucially, the courts at the time only penalized him with minor fines, proving they did not view him as a flight risk."
They shrink the monster. What about the lack of community ties? The fact that he is essentially homeless and sleeping on floors.
The defense counters this not with rhetoric, but with a concrete structural solution. The advocate informs the judge that they have been working with the probation service and have successfully secured a guaranteed bed for Gareth at the Wayford Bail Hostel, which imposes a strict curfew. This completely neutralizes the no fixed address argument and gives the judge a mechanism for control.
But the masterstroke is how they handle the visual identification. Because Philip Bennett, the victim, explicitly identified Gareth as one of the men kicking him.
This is where the defense advocate utilizes the hunting for gaps strategy, analyzing the physical reality of the evidence.
Right. The advocate points out the biomechanics of the assault. By the victim's own admission, he was knocked to the ground and was covering his face with his arms to protect his head from the picks. The advocate submits, "Your Honor, presumably Mr. Bennett was protecting his head during this chaotic melee. It is physically unlikely, therefore, that Mr. Bennett would be able to say for certain, with his vision obscured, that he definitively saw Mr. Davies land a blow, as opposed to Mr. Jones."
They use the logical physical reality of the victim's defensive posture to cast a shadow of doubt on the certainty of the prosecution's star evidence. It is a brilliant piece of cognitive redirection.
But, and there's always a but, the story takes a dark turn. Because as we move to the second part of the case study, it turns out Gareth's story about being the peacemaker was a complete lie. The police recover CCTV footage from an alleyway near the chip shop. The video clearly shows Gareth actively kicking the bouncer. Gareth's defense is destroyed by objective reality. He has no choice but to change his plea to guilty.
Which brings us to the second hearing in the case study, the plea in mitigation. The goal has shifted entirely. Gareth is no longer fighting the charge. He is facing serious, imminent jail time for a violent, drunken assault. The advocate's job is no longer to argue the facts, but to influence the sentencing.
And the advocate is handed a pre-sentence report prepared by a probation officer named Enid Barton. And this report is an absolute goldmine of human tragedy.
It is the raw material the advocate needs to contextualize the crime.
The report reveals that Gareth isn't just a violent thug. He has severe chronic alcohol abuse issues. It reveals that he is functionally illiterate, having truanted from school for years to escape severe childhood bullying. And perhaps most powerfully, it reveals that he is desperate to reconcile with his estranged wife, and that his wife actually attended the probation interview with him to support his recovery.
The tactical challenge here is immense. The advocate must not sound like they are making excuses for a violent assault. Judges despise advocates who minimize the suffering of the victim. The advocate must acknowledge the severity of the crime immediately, but then they weave these painful personal details into a narrative of a man who is drowning in trauma rather than a man who is inherently malicious.
The manual describes the ultimate strategy for this hearing as showing the court the way home. I thought this was such a profound phrase. Mechanically, what does that mean? How do you show a judge the way home?
Showing the court the way home means understanding the psychological burden on the judge. Judges want to protect the public, but they're also deeply aware that throwing a broken, illiterate alcoholic into a crowded prison for 6 months usually just creates a more dangerous criminal upon release. The judge wants an alternative, but they need a legally sound, highly structured alternative that justifies keeping a violent offender out of a cell.
So the advocate builds them a bridge.
Exactly. The defense advocate uses the probation report to suggest a high-level community order. But they don't just ask for vague leniency. They specifically request a community order heavily burdened with conditions, a mandatory alcohol treatment requirement, and a compulsory anger management program.
They give the judge a highly engineered roadmap. The advocate is essentially saying, look, judge, I submit that if you lock this man up, he simply sits in a cell and stews in his anger. But if you adopt this specific community order, we aggressively treat the root cause of the violence, the alcohol dependency. We force him into rehabilitation. This allows him to maintain the support of his wife, seek employment, and ultimately protects the public far better than a short custodial sentence.
You are solving the judge's problem for them. You aren't begging for mercy. You are providing a pragmatic, structured, systemic solution that satisfies the justice system's dual mandate of punishment and rehabilitation. It is the absolute culmination of every single skill we've unpacked today.
It really is. It takes the ability to analyze cold facts, the empathy to understand human psychology, the situational awareness to read the judge's needs, and the discipline to use highly structured, deferential language to persuade an authority figure to adopt your worldview.
The manual ultimately reveals that the legal world recognizes a fundamental truth. Human communication is flawed, emotional, and inherently chaotic. By applying these rigid, mechanical frameworks, controlling the autonomic pitch of the voice, deploying the silence of active listening, utilizing the cognitive guardrails of the T-funnel, and hunting for the absence of evidence lawyers, impose order on that chaos.
And that is the beauty of this deep dive. You do not need a law degree to use these frameworks. They are universally applicable. The next time you walk into a high-stakes conversation, whether you are negotiating a salary bump with a frugal boss, navigating a tense dispute with a neighbor, or trying to figure out what went wrong on a massive project at work, take a second to analyze your own mechanic.
Yeah, pay attention to it.
Ask yourself, are you just reacting emotionally, or are you actively managing the top of the T-funnel? Are you arguing about what the other person said, or are you hunting for the gaps in their logic? Are you letting your stress dictate the pitch of your voice, or are you controlling your metronome?
The architecture of the courtroom is sitting right there in your everyday life, waiting for you to use it.
Remember how we started this? Thinking of a conversation as a natural, meandering river. Well, maybe it's time to stop just floating passively down the current, hoping you end up somewhere safe. Maybe it's time to build a dam, divert the water, and engineer exactly where you want that river to go. Thanks for taking the deep dive with us. See you next time.